I'm investigating, okay?
Okay, but
That's
are
what
you
I need you to
asking for my
understand.
identification or
I'm asking you for name and date of birth.
So
That's
you're
all
asking.
I'm asking for.
asking, right?
That's it, brother.
Oh, don't answer questions.
I got all night.
You want to call out?
No, you know what? You don't need a supervisor because what's going to happen is, dude, I'm going to place you under arrest for failure ID, okay? And that's going to be on you, not me, brother.
So you already said that.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, and former police officer. Well, friends, the auditing community's most popular pre-law student is at it again, and this time, he may have a serious lawsuit with damages on his hands. About a week ago, a YouTube channel for Joel Martinez posted a video of him being arrested and subsequently released by a New Mexico police department because he refused to identify himself. In case you're not familiar with Joel or you don't remember, he first became YouTube famous for this epic ID refusal on New Mexico State University campus when he was accused of carrying alcohol into his dorm room.
I need you to tell me if you don't give me your ID right now, I'm going to arrest you.
Why would I say that to you?
Because I need that ultimatum, because right now you're asking.
Yes.
And I have the right to say no.
We need to see your ID.
Okay, and if not?
And if not, you could be considered
Could?
concealing ID. Okay, so do you have any alcohol in your possession?
I don't answer questions. On what grounds?
Okay, so you don't have any alcohol in your possession.
On what grounds? I don't answer questions.
Now, Joel wasn't arrested during that encounter, and he gave his ID under threat of arrest, and I assume no litigation came of that. This time, the cops were a little quick on the trigger, and I have a sneaking suspicion they're going to sponsor young Joel's law school education. Now, for clarification, Joel is an undergrad student as a criminal justice major. He's only 19 or 20 years old. Maybe the common vernacular in that area is to refer to CJ students as law students, but he's not a law student in the sense that he's in a graduate level program to become a lawyer. Yet. So the story is, Joel bought a car from a local salvage yard and was inside the yard looking for spare parts for it when he accidentally dropped his keys. Being close to closing time, the salvage yard allowed him to look all over the 30-acre property, but when they had to close the gates and he hadn't located the keys, the staff at the salvage yard loaded the car he had bought up on a forklift and moved it outside the gate so he could call a locksmith. The video starts when the cops show up in response to a call reporting suspicious activity on the outside of the salvage yard. But you should head over to Joel's channel to watch both videos in their entirety and give him the credit for sharing them. Let's get into it.
Hello. Buenas noches. Alcir Mendez, mucho gusto.
¿Cómo está?
Bien, bien. How you doing, brother?
Doing good.
All right?
Yeah. I lost the keys in the junkyard over there.
Okay.
So I called them to come and get the
come open
the car. The car is the one that lost the keys. I lost the keys to the car.
Oh, like you went into the property and you dropped the keys?
Yeah.
Yeah.
When I was leaving is when I found out I didn't have my keys. They let me go in, look for them all over the 30 acres of cars they have.
Okay.
They didn't find them, so they just grabbed the tractor and moved the car outside so I could call them locksmiths.
What's wrong with it besides the key? It starts?
Yeah, it starts and everything. They just came in and picked up some spare parts.
Oh, okay. But they closed the gate behind you or what?
Yeah, they just moved the car here and they closed the gate over.
Okay. What's your last name, brother?
Just Martinez.
I'm sorry?
I don't want to give I didn't invite any information. I'll just give you my first name, Joel.
Well, I need your info, man, because I'm talking to you, brother, because you're the person that they called on. So, Martinez, first name?
Nah, it's chill.
What's that?
It's just like that. I'm not gonna give my information right now.
Now, you're the person they called on. I need to find out who you are. And you're telling me one thing, so I got to call the property manager and ask them if they were the ones that allowed you on the property.
Yeah, that's the investigation,
See,
right?
Yeah. So I need your name, brother.
Well, I gave you my last name, and you could just call the property man. And
Do you have an ID?
I do.
You mind if I see it?
I do. Well, we'll leave it like this, and we can call it choose. I'll give you my last name, and that's about it. Because at the end of the day, I'm not legally provided to give you the full name. I'll just leave it at the last name, bro.
Okay. Well, here's the thing, is, brother, and I don't know. I don't know where you heard this from or what, but now if you fail to ID yourself, I'm asking you lawfully to see who you are. You're the one making it difficult. Now, if you want to impair my investigation, that's fine. That's on you. Okay, but I don't think you want to take it to that extent, brother. For giving me your name and date of birth, I'm going to warn you now, brother. You don't give me your ID or your full name, I'm going to arrest you for failure to ID.
Okay, so
because I'm investigating, brother. That's all I'm doing.
Okay. It's fine like that. Okay, I'll give you my name after what I say this.
Okay. All I need is your name and date of birth, bro. That's it.
Calls are not reasonable, articulable suspicion to suspect me of a crime under Florida versus J.L. under the Supreme Court.
But I'm not here to argue with you.
Yeah, I'm not here to argue. I'm here to defend my rights.
So I'm asking.
I'm a law student. I thought you were a chill officer when you go down like, hey, I'm my hands, whatever. They're like, hey, okay, he'll respect my rights. I'll just give you my last name.
But you're the one making this difficult. All I'm asking for is your name.
It's really not difficult. and it's not impeding your investigation because it's not a physical, or it doesn't, giving you my ID doesn't help you out.
You're in law school, right? You're a law student? Okay.
Yes, sir.
I'm investigating, okay?
Okay, but
That's
are you
what I need
asking
to
for my
understand.
identification, or
I'm asking you for name and date of birth. That's
you're
all
asking-
I'm asking for.
asking, right?
That's it, brother.
Don't answer questions.
I got all night.
You want to call out?
No, you know what? You don't need a supervisor because this is what's gonna happen is, dude, I'm gonna place you under arrest for failure ID, okay? And that's gonna be on you, not me, brother.
So you already said that it's going to be under arrest?
Yes.
I
Go
will
ahead,
be
go
under
ahead, turn
arrest if
around.
I don't give you my
Go ahead and
identification.
turn around, brother. Go ahead and turn around.
So I'll give you my ID or
Go
not.
ahead and turn around. No. Put your hands on the car. You already failed to identify yourself. Okay. Give me your left. Give me your right arm. You want to play games, brother. I'm here being nice, and you don't want to give me your name and date of birth. Listen. All right. Stand right there.
First I'm on the back of the car.
Man, you see you're a law student, brother. ¿Qué pues?
And you'll
All
see.
you had to do was give me your name and date of birth.
You'll see. You'll see when we get to the station.
Now, the civil rights lawyer, John Bryan, already did an awesome breakdown on the 10th Circuit's guidance regarding reasonable suspicion on his channel, so check out his video, which I'll also link in the description. What I want to focus on is the New Mexico Concealing Identity Statute, and then I want to go over a recent appeals case in New Mexico that gives us a really comprehensive view of how complicated the reasonable articulable suspicion analysis is, and how a case can change from the initial phases through the trial and appellate phases. In my opinion, this officer didn't have reasonable articulable suspicion under the current case law guidance, because you'll learn as you do a deep dive into the case that it was based on a likely anonymous call, which, as John Bryan points out, is insufficient alone to establish reasonable articulable suspicion for a crime under the 10th Circuit jurisprudence. The call reported suspicious activity, so the only real crime that they could have been investigating with particularity was either trespass, which requires the owner of the property's participation, or something more serious like burglary or breaking and entering. Both of those things were pretty quickly resolved upon the officer's initial, albeit half-hearted investigation. Remember that reasonable articulable suspicion is based on the facts known to the officer at the time, but once those facts are established, the court puts on a pair of reasonable officer glasses in order to view those facts through the lens of a reasonable officer in a similar situation. This creates sort of a peer review style comparison between what actually happened and what a reasonable officer would have done under the same or similar circumstances. Now, I do have the benefit of having been a police officer, so I'll give my thoughts about what a reasonable officer would see in this encounter. So number one, the call was about suspicious activity. No one said anyone was breaking in. No one alleged any specific crime. So that basically weakens the officer's justification almost immediately. As far as we know, the call was somewhat anonymous, but I'd say certainly not placed by the property owners, because we later learned that they let him look around for a while and then assisted him with moving the car outside. They really had no reason to question why he was there or what he was doing. So the caller was very likely not anyone associated with the business of the salvage yard. Number two, Joel didn't immediately shut down when the encounter began. He explained why he was there, how he got there, and what he was attempting to accomplish. He clearly had a car with no keys. There was clearly a locksmith who gave a consistent story, and the car didn't magically become immobilized in front of the property gate. He only began to get protective when he realized that the very plausible and reasonable explanation he gave was not enough to dispel the officer's suspicions, and he was becoming the target of a criminal investigation. Number three, no one calls a locksmith to help them while they're in the process of breaking into a business or trying to commit a crime. I mean, if you're going to ask for help, you're going to do it from a known person who you believe will keep your confidences, like your buddy with a chop shop who also has a tow truck, or your car thieving buddy who knows how to hotwire cars. You don't mix criminal activity with legitimate business by calling some rando that you found on Google in hopes that he'll be willing to risk it all to advance your spontaneous criminal enterprise. Any notion to the contrary is silly, and in fact, hearing myself say it out loud is so ridiculous, it makes me laugh. So under what I see as the totality of the circumstances here, there really is not any reasonable articulable suspicion of criminal activity. Now, let's look at State versus Aguilar from 2021, which is a New Mexico Court of Appeals case that will give us a further explanation of why this matters so much. I'm going to explain this case as quickly as I can for the sake of time, but I've linked the opinion in the description, and I really encourage you guys to go read it for yourselves. It is one of the best plain language breakdowns of reasonable suspicion I've ever read, and it gives you some insight as to how complex the legal standards are and how they change from the early stages of a case through the trial and into the appellate level. The basics are these. Aguilar was with a group of people at a pizza restaurant. Several members of the group went to the bathroom for an unusually long period of time, and the restaurant management became suspicious that they were using drugs in the bathroom. Most of the group left, and Aguilar went outside to wait for his female companion, who was still in the bathroom, and remained in the bathroom until the police arrived. Cops interviewed the female and saw evidence of blood on her arm and believed she was using. They asked her if she was there with anyone else, and she pointed to Aguilar, prompting the police to go interview Aguilar. When police started to talk to him, he gave them a false name. And when he realized that they were on to him, he took off running. They caught him, arrested him, and incident to that arrest, they ended up searching him and finding meth, and they ended up with possession of meth and concealing his identity for giving the false name. Now, in a hearing on a motion to suppress, the state argued that the officer was told by management that he had not purchased anything, and the officer had reasonable suspicion to investigate a trespass, and he needed his name in order to properly trespass him from the property. The court then determined that his concealing his ID hindered the officer's investigation, and they denied the motion to suppress. The appeals court said that this was proper because at the time of the motion to suppress, the information before the court was that he was a trespasser. However, the evidence at trial was different than the evidence in the motion to suppress. At trial, the restaurant manager testified that Aguilar was actually a paying customer and that he did buy food. And the state, having the burden of proving their case, didn't put on the evidence that would disprove that. And they didn't put on any evidence that suggested the officer was told something different, even though that's what they said at the suppression hearing. And actually, the pizza restaurant had signs outside that said that if you weren't a paying customer, you were trespassing. So the fact that the officer testified to one thing at the suppression hearing and the manager testified to something different, and the state didn't put on any evidence to dispute that, changed the entire analysis about what was reasonable about the detention. If the officer believed he was a trespasser based on the information he got from the manager at the time, well, then he had a right to detain for trespassing. But if the same manager who allegedly told the officer that upon the initial call testified in the opposite at trial, then the state would have had to do something to try to rehabilitate the witness or provide some evidence that gave an explanation for this new information. And because they didn't, then the court said, well, if he was a paying customer, he wasn't a trespasser, so that negated the reasonable suspicion for the detention for trespassing. The court also pointed out that while the officers did have reasonable suspicion that the female was using drugs based on their interaction with her and seeing blood on her arm, the mere fact that she was associated with him did not provide reasonable suspicion that the criminal activity associated with her automatically transferred to him. So as a result of all this stuff, all of Aguilar's convictions were overturned. So as you can see, this stuff gets really complex and nuanced, and it's really difficult for any reasonable, regular layperson to understand how this operates in the real world. Now, back to Joel and his epic spanking of the police.
Alright, sir. So I'm the supervisor here. I was just made aware of what happened.
Yeah.
So I don't think it qualifies for any crime, okay?
It doesn't qualify for a crime?
I'm gonna go ahead and release it.
Of course. I want that officer's dash number.
Yeah,
this
I
is
will.
on the 7th. Oh my god, I am so fucking pissed right now.
Let me finish talking, okay?
What's your badge number?
Mine?
Yeah, or your name?
Sergeant Procopio,
Procopio?
ID 5701. I'll give you a case.
Okay, yeah. I'm gonna get all cameras, dash cam, body cam, phone calls, everything. It did not constitute a crime. Look what he did. My belongings.
Let me go get it.
Yeah.
Like I said, I just got here.
Yeah.
And I was just briefed of the incident. So I'm trying to get all the facts of what happened.
Yeah.
So based on what he told me, like I said, I would constitute the failed ID crime.
That's
But
right.
let me get it for you.
Oh,
Let me go talk to the deputy first.
can you get him here? Just so you can educate him, and so it doesn't happen
And
again.
that's why I want to get with you. But I want to ask him some questions first.
Yeah.
Is that okay?
Yeah. Lock my phone and my wallet and my AirPods.
Yeah, I'm going to get it.
Yeah.
Let me just be with you.
What about my car?
We're going to take you to it.
Okay.
But like I said, give me some time so I can try and find
Okay, so and
all
what
the
happened to
facts.
the locksmith? Because the locksmith because I lost my keys in the junkyard, and I needed the locksmith to make me a key.
Those details? I'm trying to obtain those details. Okay, what happened? Walk me through what happened.
Okay, so I was in the junkyard, right? During business hours, I was doing my job, everything with my hands. I've been working, because you can tell. Then as I'm in the junkyard, you seen how big it is. I lost my keys in there.
Yeah, you can
somewhere.
go full parts there.
Yeah, lost them, couldn't find them. They gave me a chance. It was like they closed at 5. It was like 4:30. And I was like, please let me in. Like, I fine, going. They looked and they picked me up on a truck. They said, hey, the alarms are going to activate automatically. You need to get out. What about your car? Because it was parked inside the property. I was like, well, I don't know. Like, so the owner or one of the employees gave me 3 choices. Like, okay, choice 1, you could leave it here. It's all secure. We have sensors, cameras, and whatever. If anything, well, and you'll come back tomorrow and look for your keys, or get a locksmith to make you a key, or we could get a tractor or one of the forklifts to move your car right outside. And like, if you can move my car right outside, so I could call the locksmith, it would be fine. Locksmith got there, and during this whole time I was just waiting outside, right? The locksmith got there, and he was like, we did everything right, and then I just see a patrol. I was like, whatever. I get down and it's like, hey, like, oh, we got a call, and that you were inside the property, that you were looking at, or what, he said that you were inside the property, and then like, okay, and then and then they say, okay, what's your name? He's like, what's your last name? Martinez. And he's like, okay, what's your first name? We're like, oh, I'm not gonna give it right now. He's like, okay. He's like, why not? He's like, I'm trying to I'll give you my name, whatever. He tells me, like, you know? And they're like, okay, but I'm not going to give you my name out because I'm not legally required to give it to you right now. I'm a law student. I let them know too, an MSU criminal justice major. I let them know I'm a law student, and under Florida versus JL, an anonymous call or a call is not enough reasonable articulable suspicion to articulate a crime, because RAS is only based on the facts known to the officer, right? So I told, and he was like, I don't want to hear, like, give me your ID. No, he wasn't demanding. He was asking, you know, I'm asking you for your name. I'm asking. And then until he said, well, now I'm going to arrest you. You're like, okay, that's different. You're asking, if you ask me what's your name, I'll just say, I don't answer questions. But if you demand me my ID, give me your ID or I'm going to arrest you, or give me your ID, I'm going to arrest you, that's enough. That's all I need. I could get that on the phone and be like, okay, that's enough. Show it to my attorney. That's enough for the litigation. And he said, and I told him that if you're threatening me with arrest, and I have it all on video. He said, if you threaten me with arrest, I'll give you my wallet. I'll give you my ID right now. Like, no, turn around, push me into the car, boom, put your phone down, set it up on the windshield, put your phone down, grab me, tie me up. He's like, you're a really stupid law student, aren't you? I'm like, okay, let's see what happens. Okay. Takes me into the thing, right, and I'm telling him, like, bro, you're gonna sponsor my new car? I'm telling you, you're gonna sponsor my new car. Oh, he thinks it's funny. He thinks he's a good law student, whatever. He leaves, doesn't, and I asked him to, and I asked the other, do I get my phone call? No, that's up to the discretion of the arresting officers. It's fine. What's that comedy, just waiting in the cell, disturbing anything? And as you can tell, I'm a really cordial guy. I'll talk to you, whatever. Don't disrespect me. Obviously, someone randomly goes up to you and just asking you for your name and stuff. Just nothing. It's not something you do. it's self-respect what I was doing. He arrests me, makes fun of my studies, makes fun of everything. Like, okay, you think it's funny now, but your supervisor, and when we were over there too, I told him, call your supervisor. You don't need a supervisor. Just turn around and put your hands. All this could have been saved if you would have called you. And I told him with a smile on my face, this is not what you want to do, man. This is really not what you want to do.
So how can we fix it? Okay, the deputy made a mistake. That's gonna be addressed, of course.
Well, where's the deputy? You said he was going to be here.
He's here, but I want to meet with you first.
Okay. Well, I give you my side. I would like to hear the deputy side right here.
Okay.
If that's fine.
I believe you. I'm not saying I don't.
No.
I'm just trying to get the facts as far as
Well, those are the facts.
from your point of view.
This whole thing became unlawful because first off, he never said that I was detained. Never once said that I was detained.
I'm trying to answer your questions.
Okay. This question. Okay, going back to what happened today. He never said that I wasn't detained. So as far as I'm concerned, I could have walked off. Because if you're just asking or it's a consensual encounter, I can make it unconsensual and just walk away.
There's a lot of what ifs. Yeah, I mean, I can sit here and say that, but that's why I'm trying to find the facts. First from you, then from the deputy, and then we'll move on.
Okay, I'm done with my story. You can have the deputy and give his story.
Okay. So, what are you looking for?
I'm looking for a story now, and then I'll tell you what I'm after it. I'll let you know what's gonna happen.
His story is basically your story, pretty much. As far as the
He
law.
doesn't want to see you, no? Or...
It's a different process. Of course, you do have a complaint.
Well, okay, let's put it this way. If he comes here and apologizes to me, I won't litigate this whole thing.
It's up to you. I mean, I can always, my job is obviously make it better for you. Let me go talk to him.
Yeah, because before you go, and he saw it himself too. The cop making fun of me. Oh, what a stupid law student. Oh, he thinks he's gonna get out. When we got into the thing, as soon as we got in, he was already, hey, he's a law student. He was telling the deputies, I'm not lying, they can tell you, ooh, he's a law student with a smirk, smile on his face, trying to humiliate me, making fun of me. So, have anything to say to me? No? You said, you laughed at me? You said that I was a dumb law student? Did I or did I not? Okay. Did you or did you not?
Did I not?
Did you say that I was a dumb law student?
No, I didn't say where you learned law, sir.
No, sir. You got me into the cruiser. It's on your body cam too. It's on my phone too. We got into the cruiser, and you said like, you're a really dumb law. When we were getting down here in the station too, you're a really dumb law student, aren't you? You get me into the thing, and you start making fun. Oh, everybody look at him. He's a law student. He's a law student. You left me in there with the cuffs on.
Okay.
And I told you. Didn't I tell you that what you were doing was unlawful? Did you believe me?
No, it's not that I didn't believe
Okay.
you. I
Did you get the supervisor when I asked you to?
Okay.
No, you said I didn't need one.
No, I never said.
It's on your body camera. It's on my phone.
Yes,
Don't lie.
you asked for a supervisor. Well, what did I tell you?
You said you don't need one. Turn around and put your hands behind your
No, I
back.
told you we're not going to get one until we get to the station.
You know what? You don't need a supervisor because what's gonna happen is, dude, I'm gonna place you under arrest for failure ID, okay? And that's gonna be on you, not on your brother.
No, you didn't. It's on your body camera.
I wouldn't disrespect my supervisor like that, man.
Well,
because
you are.
we were in the motions, and and I'm in the wrong. I really am. I'm not gonna lie to you, brother. Okay?
You are in the wrong, and I told you were in the wrong, and I told you were gonna, and I told you all this, and what you thought was funny.
I never thought it was funny.
No, you laughed. You walked in trying to make everyone laugh.
Funny were your comments, brother. That's it.
What were my comments?
Your comments that you're saying Florida code this. I'm gonna get a new Mustang.
Florida versus JL. That's case law. You don't know case law? I can tell. Because you unlawfully arrested him. It wasn't a mistake. He broke the law. It's not a mistake.
And that's what we're here.
That's
That's
what
why we're here. And now, you are going to buy me a new Mustang. You are. Because now all this, that's going to get for you that request. Your dash cam in your car, everything. My phone, your badge numbers, everything's going to come into one single file record. It's going to come in here tomorrow. And that's going to go straight to my attorney. And how do you think? And you lost your qualified immunity right now. Right now,
Okay,
you're by
sir.
yourself.
So it's getting out of control. You said something different to me before. Take off. I will take your complaint.
Well,
Is there anything else besides what you told me at first that has changed, or anything else that we have to add to your complaint?
No, that's fine. I'll see you in court.
So Joel is arrested, as we saw in the video. The supervisor shows up, and he does the right thing, at least partially. He's trying to get to the bottom of it. He's trying his best to do what he can, but he's also being a little defensive and trying to explain away what the officer did. And I'll say that the biggest mistake that I've seen these cops make in dealing with Joel is underestimating him. He's a smart dude, and for somebody his age, he can think circles around most adults. I can guarantee you these cops did not want that smoke that they were fixing to walk into, and this is a masterpiece manipulation by him. He asked the supervisor to get the deputy's side of the story. The supervisor then asks how they can make it right, and I genuinely believe Joel meant this. He says if the deputy comes out and apologizes, that he won't litigate this whole thing. And I think had that happened, Joel would probably have had his lawyer write a demand letter. Maybe they pay for the locksmith. If the car was eventually towed, maybe they pay the tow bill, an apology, a promise to enhance training, so on and so forth. But this wouldn't have become a lawsuit, I don't think. Not a full-fledged lawsuit. It might have been a demand letter followed by a small settlement. But that's not what happened. What actually happened is the cop comes out and for the most part refuses to accept responsibility. But he gives us a combination of that body language and the kind of silence that only attacks a person when they know they're caught and have no idea how to respond, to let you know that he knows he's screwed and he has no defense. But here's the part that really turns my crank when it comes to this case. We are all here, all of us watching this video, because when Joel realized that he was seriously in jeopardy of being accused of a crime, he shut down and he exercised his constitutional rights. Deputy Mendez was so bothered by that he let his ego get the best of him and not only arrested Joel unlawfully, but taunted him in the process. And did any of you guys pay attention to what the supervisor and Deputy Mendez did when they faced the realization that they'd been manipulated into making statements against their interest? That's right. The supervisor shut down the confrontation and Deputy Mendez refused to concede much of anything, and he eventually left and the supervisor followed up with the complaint. And here's why. They both know that what follows this is an internal affairs investigation. And when you're a police officer and you're being investigated, the department can fire you for not cooperating. As such, they give what's commonly referred to as a Garrity warning. A Garrity warning operates sort of like an immunity agreement. It basically says, look, administratively, we're going to require you to answer truthfully all of our questions. And as part of that, you might say something that would ordinarily incriminate you because you may have committed a crime. If you don't answer our questions or you lie, we're going to fire you. So we're going to require you to answer our questions. But under the Garrity warning, we're telling you that anything you say in your cooperation with our administrative process will not be used against you in a criminal procedure. And so it sort of works like an immunity agreement. If you tell us the truth, we won't give this to the prosecuting authorities. So Deputy Mendez and his supervisor both realize that as Joel is questioning him on camera, Joel doesn't owe him a Garrity warning, and there's no immunity agreement, and anything he says on camera to Joel will be subject to a FOIA request and fair game for use against him should a prosecutor somewhere decide to investigate him for a crime or like malicious prosecution or something like that. So what does he do? Well, he does the thing that brought us here in the first place. He decides to remain silent. He exercises his Fifth Amendment rights, knowing full well that not only will he not be punished for it, he will have the full support of his supervisor during the process. And that is so hypocritical that it makes me sick. My closing argument is that I actually think the most valid argument against concealing identity in this case was made by Joel himself. I mean, of what value does somebody's ID actually have in the grand scheme of things? I mean, sure, if you need to trespass somebody from the property, you have to know who they are so that you can make sure that the correct person is given notice. But you have to establish a trespass first, and you have to do that by undertaking an investigation. What you might not know, as the general public who's never been in law enforcement, is that almost every police department has a records division. And within that records division is kept a list of key holders of all the businesses or most of the businesses within that jurisdiction. They do that in case there's like a burglary and a glass window gets knocked out and somebody has to go wait by the business to secure it while somebody has to come out and repair the window. Or maybe an alarm goes off and the security company can't get anybody to answer the phone, so they're trying to figure out from a key holder, you know, whether there's somebody authorized at the building at that time or not. That means that there was an avenue for investigation to figure out whether or not it was the business owners that were calling in the first place. What happens is cops don't get good training on the Constitution, and so they forget where their authority comes from, and they eventually supplant their ego as the authority. And they get themselves so spun up by people exercising their rights and how offended it makes them that they forget that there are other ways to investigate besides people snitching on themselves. I mean, how about calling the 911 caller back and getting some clarity? How about reaching out to the key holder on the property? Do you even have a crime to investigate? If officers were constitutionally intentional about the way that they approach their investigation, they wouldn't find themselves in these messes to begin with. What we all collectively see as the most common thing in these videos is an officer saying, "I'm conducting an investigation," followed by the same cop-splaining garbage that we always get. Word vomit evidencing an extreme misunderstanding of the law, coupled with an extreme misunderstanding of their own department's policy, combined with the most prominent ingredient of a bad arrest of all, and that is the officer's out-of-control ego. The problem is that all of the focus is on the "I'm" part of the statement, and none of the focus is on the conducting investigation part. Guys, you can still investigate without coercing people to self-incriminate. Go do it. And you may find that you don't need to traverse this hill that you're willing to stake your entire career on because there's actually nothing going on to investigate in the first place. Or you might find that you got all the justification you needed to make an arrest because you undertook the reasonable steps necessary to require it before you demanded it. Anyway, what do I know? Maybe if we can get to a place where the cops will give people a little fist bump, showing respect to the game whenever a citizen is aware enough of their rights to invoke them, and force the cops to actually do the hard work of investigating, we'll start seeing less of these videos, and the world will be a better place where public confidence can be restored in the institution of law enforcement. But my guess is that ain't going to happen, and you guys will have to just keep dealing with me complaining about it over and over again. That's it for this one, guys. Thanks for spending your time with us. Please remember to like and subscribe. Check out the other videos on the end screen and leave me some comments on your thoughts. Until next time, take care of yourselves. Always film your interactions with the police and keep your evidence to yourself.